afternoon, or good evening, depending on where you are in the world, and welcome to Finnegan's Webcast, a US and EP comparison on added subject matter. My name is Darren Geron, and I'll be your moderator today. And it's my pleasure to welcome our presenters, Vicky Barker and Sarah Rodriguez. Both Vicky and Sarah are resident in Finnegan London's office together with me. Vicky is a UK and EP patent attorney. She has a doctorate in chemistry, and she's an expert in European opposition proceedings and appeals, as well as patent prosecution in pharmaceutical and other chemical-based technologies. Sarah is a dual qualified UK and EP patent attorney as well, but she's also a US lawyer and US patent attorney. She has a background in engineering physics and electrical engineering, and she used her background to prosecute patent applications both in the US and Europe in technologies ranging from semiconductors, nanotechnology, to software and optical devices, and pretty much everything in between. She also devotes much of her practice to oppositions in Europe and post-grant review proceedings in the US. Before I turn things over to our presenters, I invite everyone to participate by submitting questions. It's an interactive webinar, so just click on the Q&A button at the bottom of the webcast interface and type your question in the Q&A window, then click Submit. The questions will be answered today during the question and answer session, which will take place at the conclusion of the presentation. If you're experiencing any technical difficulties, please click on the webcast help guide button in the lower center of the webcast interface. And now I will turn it over to our presenters to begin our presentation, a US and EP comparison on added subject matter. Welcome, Sarah and Vicky. The floor is yours.
Hi, so I'll get started with just a high-level overview of the differences between the two jurisdictions. So before I get started with that, let me just give a brief overview of my own background. So I started in the US. Initially, I trained as a US patent attorney, and then I moved to Europe and I trained as a European patent attorney. And for the most part, it was a really smooth transition. There's a lot of harmony between our two jurisdictions, but there were a few areas of the law that required significant rewiring of my brain to adapt to European procedures. And added subject matter is definitely one of these areas. So I want to present these two differences with images. So when I think about Europe and I think about added subject matter, I think about a really rigid system, extremely structured, something with a high threshold to overcome. So I think about this image. Proper gentleman smoking a pipe. And if I want to think about a corresponding image of how I would interpret the differences of how added subject matter is evaluated in the US, I would think about this image. So it's definitely much more mellow, much more relaxed, quite different. Definitely, it's not the Wild Wild West. I mean, there's still evaluations that need to be made, but I would say that the standard of review is not as strict as it is in Europe. And we'll go through some examples that highlight that. So let me just begin with showing how the concept of added subject matter is even introduced in the respective guidelines of the two jurisdictions. So let's get started with Europe. So this is an excerpt from the guidelines of examination. And here, this is how we address added subject matter, or how it's introduced. So an amendment is regarded as introducing subject matter if the overall change results in the skilled person being presented with information which is not directly and unambiguously derivable. So this is a key phrase, and you'll see it come up again and again. It's known as the gold standard. So from what is previously presented by the application, even when account is taken of matter which is implicit to the skilled person in the art. So let's take a look at how added subject matter is introduced in the MPEP, which is the examining Bible of the USPTO. Matter not present on the filing date of the application in the specification, claims, or drawings that is added after the application filing is usually new matter. So much different treatment on how these different on how this topic is introduced in the different jurisdictions. So before I go into further detail on the statute of each jurisdiction and how the steps of evaluating added subject matter in each jurisdiction, I just want to give an overview of who the skilled person is in both these jurisdictions, because the way I wrap my head around this and how I make sense of these great differences is that I believe the skilled person is evaluated differently in both of these jurisdictions. So if I was, again, let's illustrate this difference with a picture. If I was going to have a picture of the European skilled person, it would be someone like this. So perhaps a research scientist or a postdoc. And the US skilled person would look something like this. So Stephen Hawking. So I admit this is an extreme comparison, but what I'm trying to say here is that the US skilled person is much more intelligent, and the USPTO gives a lot more credit to the skilled person and what that person is able to do than the EPO. So let's take Inventive Step, for example. So in the EPO, they'll evaluate the skilled person and they'll consider, can this person combine more than 2 references in absence of a partial problem? Probably not. But the USPTO will look at that same scenario and say, can a skilled person combine more than 2 references in determining obviousness? And yes, they definitely can. And the same with added subject matter. The EPO will consider, can a skilled person, given the specification on filing, can they appreciate that maybe there's other embodiments included that are not explicitly disclosed, other combinations? And generally, that's going to be a harder threshold to pass in Europe. But the US, this will be a bit more relaxed threshold, and they will give the skilled person a lot more credit. So let's talk about how added subject matter is evaluated in the different patent offices. So here, this is dictated by Article 123.2 EPC in the EPO. And this basically states that the European patent application or patent may not be amended in such a way that it contains subject matter which extends beyond the content of the application as filed. So there's generally 3 ways of adding content. It could be by addition, deletion, or substitution. And basically, any changes that result in a change in the combination of features that are presented or any of the information that's presented in the application. And generally, an addition, deletion, or substitution will be means of how added subject matter would be affected in the US as well, or be added to an application. So in general, in order to determine if there's added subject matter, there's going to be a comparison of the application as filed with respect to the application after the amendment. And that's any amendment to the description, figures, or the claims. And so basically what it all boils down to, this comparison, is a novelty test. And you'll see that while the statute doesn't require literal support, so in theory, but in practice, actually the examiner more often than not will require this. And so here, let's look at case law derived guidelines of how you apply this novelty test. So first, the original application is not a reservoir of combinations of features that are combinable at will. So if there's different embodiments in the application, you can't just combine the different features or try to claim one of the examples removing a feature. So this will lead to an intermediate generalization. And this is an objection that very often comes up in Europe, and we'll talk about that in detail here today. A second point of review is determining what is directly and unambiguously derivable from the original application or patent. So again, this is the key phrase, the golden standard. This will come up quite a bit. And then a third point of evaluation is determining if the allowability of the amendment should be beyond any reasonable doubt. So this is quite a high threshold. So let's talk about what an intermediate generalization is. So amendments can add matter if they give rise to an undisclosed combination of features lying somewhere between an original broad disclosure and a more specific limited disclosure. So this generally comes up when you have an example in the application. And let's say you have a device with elements A, B, and C, but you want to claim a device with only elements A and B. This will lead to an intermediate generalization, and this will create alarm bells in the examiner. And he will, more often than not, try to restrict you to the specific embodiment that's been literally disclosed in the application. So because of this, it makes it difficult in Europe to rely on examples or specific embodiments or the figures for basis of examination. So your best basis for amendments would be the claims and the multiple claim dependencies. So let's go through the statute in the USPTO. So this is 35 USC section 112. This sets forth the requirements for the specification and the claims. In subsection A, this sets forth 3 requirements: written description, enablement, and best mode. So when you have added subject matter objections, it's written description that's more often than not raised as an objection related to added subject matter. And so here we can see a quote from the MPEP. If an applicant amends or attempts to amend the abstract, specification, or drawings of an application, an issue of new matter will arise if the content of the amendment is not disclosed in the application as filed. So similar to what we've seen in Europe, but one main difference between the US and the EPO is the relaxation of needing literal support in the application. And we'll go through some examples which highlight this. So let's talk about basis for amendment. What can you rely on for the basis of an amendment in each jurisdiction? So let's start with Europe. In Europe, the content of the application as originally filed can be relied upon, and this includes the description, the claims, and the drawings, but not the abstract. You cannot rely on the abstract for amendments in Europe. Amendments to the European application, they can be made, but you must consider that the European application is not a reservoir of features that are combinable at will. This is a phrase that will come up quite a bit. And basically, this leads to an intermediate generalization. In Europe, there's a lot of focus on the explicit disclosure of a specific combination, and that has to be paid attention to a bit more strictly than you would have in the US. So let's look at what is used as a basis for amendment in the US. So the entire application is used. And while there's no statute on point, I would say that more so is the case rather than with the EPO, that the application is more of a reservoir of features combinable at will. And the reason why that is because the US relies on more so on boilerplate language in the application that describes that different features of different embodiments can be combined. And the US also relies more on the word may. There's an emphasis that the different features are optional. Whereas those sorts of things will not be given as much weight in Europe. So again, it's difficult to have a hard and fast rule of that this will always be the case in the US and something else will always be the case in Europe. Really, it depends on the facts of a specific situation, and more so it depends on how things are described in the specification. But I would say that it's easier to combine elements from different examples or to claim a device based on an example without claiming every single feature within that example. So let's talk about how the different contents of the application are interpreted. So again, the golden standard. This is very important. It comes up all the time. You have to consider, can the skilled person derive directly and unambiguously the subject matter to be added by way of amendment from the application as filed? You can also take into consideration common general knowledge and any features which are implicit to the skilled person in the art. And so again, while literal support is not required in the statute, examiners will often require this. And so in the US, these are phrases taken from the MPEP. This is a cut and copy of ways of how you can interpret the application according to the MPEP. So mere rephrasing of a passage does not constitute new matter. Mere inclusion of dictionary or art recognized definitions known at the time of filing an application may not be considered new matter. So an example from my own personal practice, there was once that I worked on an optics application and I wanted to amend the independent claim with a feature from an example. And that feature was a mirror, but I didn't want to I thought a mirror was too limiting. And in the independent claim, what I added instead was a reflective surface. But I didn't have explicit support for a reflective surface, but I mean, it's well known the skilled person would appreciate that a mirror is a reflective surface. So in Europe, I would probably shy away from making such an amendment. I think that would be an extremely difficult amendment to be allowed if you didn't have explicit support for a reflective surface. But in the US, it's not ridiculous to try. I mean, you don't know how the examiner will treat that, but it's something that I would definitely try. So another phrase from MPEP. So a patent application is disclosing a patent application a device that inherently performs a function, has a property, operates according to a theory, or has an advantage. The patent application necessarily also discloses that function, theory, or advantage, even though it's not explicitly stated. And one major difference between the two jurisdictions is that the incorporation by reference is treated as part of the text of the application as filed. So when you're in prosecution in Europe and the examiner sees a statement of incorporating something by reference, often they will request that that statement is deleted. And when we receive notice of allowance in Europe, there's 71.3 communications, often the examiner will make suggested amendments in order to put the application in condition for allowance. And this will always be something that the examiner will strike if you haven't striked it yourself during prosecution. So now we're going to go through some practical examples and pitfalls arising from these differences.
Thanks, Sarah. So we're going to kick off with a poll question on allowable combinations, just to get the temperature of the audience. So you have 3 claims, claims 1, 2, and 3. Claim 1 is a device comprising A and B. Claim 2 is the device of claim 1, further comprising C. And claim 3 is the device of claim 2, further comprising D and E. The only additional disclosure that you have in the description is the device comprising A and B and further comprising G and H. So our question for you is A plus B plus D an acceptable combination of features at the EPO and the USPTO? So we're going to leave that question up there so you can just have a read through. And then we'll move to the poll slide, and I believe you should be able to select one of A, B, C, and D. So A, the amendment would be allowable in both the EPO and the USPTO. B, the amendment would be allowable at the EPO, but not the USPTO. C, not allowable at the EPO, but allowable at the EPO, allowable in the USPTO. And D, not allowable in either jurisdiction. I'm going to move ahead to the poll slide. And hopefully you will be able to submit your answers. Okay, great. We're having a good selection of answers coming in. So I'm going to see what you're thinking. Yeah, and pretty much everyone here is getting that answer right. As you might expect, it's not allowable at the EPO, but it is allowable at the USPTO. So we have another example here, and I'm going to let Sarah talk through this one.
Well, so here we're going to talk about all the possible combinations given the same exact fact pattern. So again, we have claim 1 consisting of elements A and B, claim 2, element C, claim 3, which depends on claim 2, with elements D and E. And again, the specification having explicit disclosure of A, B, G, and H. So let's talk about this case in Europe first, and I'll let Vicky handle that.
Yeah, so essentially you can only claim what you said you wanted when you drafted the application. So you have the combination, you have A and B already from claim 1. You can have A and B plus C, which is claims 1 and 2. You can have A plus B plus C plus D and E, which is claims 1, 2, and 3. Or you can have A, B, and G and H. And that's really the limit of what you can have. And I'm going to hand back to Sarah because this bit blew my mind when we were preparing the slides.
Okay, so let's see. So just to click through here, just the different embodiments. So here, this is explicit support, claims 1 and 2. Here you have elements A and B from claim 1, and then element C from claim 2. Explicit support, quite clear. Claims 1 and 3, you have A and B from claim 1, C from claim 2, and D and E from claim 3. So a combination of claim 1 and 3 has to include claim 2. If not, that would probably most likely be an intermediate generalization, and that will raise alarm bells for the examiner. And from the amendments based on the specification. Here you have literal support A, B, G, and H. And again, the examiner will most likely look for explicit literal support. And here, let's look at the USPTO. Many more combinations that are possible. Let's just do a quick walk through them. So a combination of claims 1 and 2 will yield A, B, and C, similar to the EP case. A and B, elements A and B from claim 1, and elements C from claim 2. So what happens if we try to combine claims 1, 2, and 3? So the first case is similar to the European case that was described before, A, B, C, D, and E, explicit disclosure for the combination of all the elements in claims 1, 2, and 3. But look what else is possible, A, B, C, D, and E. So here that binds support from claim 1, all the elements of claim 2, and then from claim 3, we only include D. So is that possible? Can we have a new independent claim omitting feature D? And the answer of that is it depends. How did the specification describe the interworking relationship between D and E? Was it described as being essential or important? Or could you say that the skilled person would appreciate that the device did not need feature D, did not need feature E in combination with feature E in order for feature D to work with A, B, and C? And so this is an argument that's possible to make in the USPTO where it would be really difficult to make before the EPO. And similar, A, B, C, and E. You have all the elements from claim 1, all the elements from claim 2, and just E from claim 3. And that's an amendment that is completely acceptable and not crazy in the US, but would be very difficult in Europe. So let's look at all the possible combinations relying on support of the specification. So here, same situation as the EPO. Explicit literal support for A, B, G, and H. What if I just wanted to do A, B, and G? And that is also possible, A and B and G. Again, it depends on how the working relationship between G and H is described. Is it described as being for the two elements or features to be working together? Or could you make an argument that the skilled person would appreciate that device with features A and B could also feature G alone? And similar treatment with A, B, and H. A and B from the specification and just feature H. And now let's look at the combination of claims 1 and 3. And so all of these combinations exclude feature C. And so here's the, from the poll question, this is the exact same pattern. So A, B, and D, and that's fine, excluding the multiple claim dependency of claim 2. So again, it depends on how the specification describes the relationship with feature C. Is it described as necessary? Would the skilled person appreciate that the device can function fine without feature C? If so, then that's an amendment that's worth making. And same thing, A and B alone with feature E. And as well, this is A, B, D, and E, all the features of claim 1 and all the features of claim 3, excluding claim 2. So let's see. Right. And now I will have Vicky set up another question dealing with intermediate generalization.
Okay, so as I think we kind of decided at the EPO, if you have a claim that just has element A and then a dependent claim that has B and C, it's quite easy to claim A, B, and C. But what if you only want to have A and B and you don't want C anymore? What do? Well, as we've discussed, explicit support or literal basis is for A and B alone is really what's preferred here. Otherwise, you need to satisfy a 3-point test from the guidelines and meet this gold standard test. I'm going to go into the 3-point test in more detail, but I'm just going to quickly hand back to Sarah to show you how much easier this is at the USPTO.
So how would I do this in the USPTO or before the USPTO? I would amend claim 2 to delete feature B, amend claim 1 to add feature B, and I would state that support for this amendment is found in at least the claims as originally filed. and I would call it a day. I would try that. So basically, again, it depends on how the working relationship between B and C is described in the application. With the skilled person, envision a device with just features A and B. It depends on a case-by-case basis, but for the EPO, I think that would, again, definitely raise alarm bells for the examiner. But here in the US, not as much. So it's definitely worth trying.
Yeah, so removing a feature from a claim or replacing a feature from a claim is really quite difficult at the EPO. So you have to meet the gold standard test, which is the direct and unambiguous disclosure that we've mentioned before. But you also have to meet this 3-step test. And this is really quite difficult to do. So if you wanted to take out component C from our previous example, you would have to show that it was not explained as essential in the application as originally filed. But you would also need to show, to meet the second criterion, that it's not relevant for your inventive step. So if it's it would really have to be like a very peripheral thing for you to be able to remove it. And the final criterion is that the skilled person needs to understand that the replacement or removal requires no modification to the rest of the claim, so it doesn't alter the invention. This can be quite tricky if you have, say, a composition and you want to take out one of the components. If the amounts of the components need to add up to 100%, if you're taking something out, you've got to add something else in. So you are changing one of the other features to compensate for the change that you're trying to make. So it's not impossible to remove a feature from a claim, but it's not easy. And I have an example that actually this came from my real life practice, that we had a method claim that was drafted, not by me, but it was drafted having 4 steps. It was a chemical synthesis, essentially, just having steps A, B, C, and D. And the client realized that the product formed at the end of step A was commercially available. And this meant that third parties could work around the claim by just buying that product. And they would only need to carry out steps B, C, and D. So they wouldn't infringe the claim. So we had to try and find a way to take out step A. Now, I can't go into detail because it concerns a real life case about what we did. But suffice to say, it was quite complicated. And what we ended up doing actually was, because we realized this in the international phase, we filed in some of the European national countries as well as the EPO, because the national courts tend to be slightly less strict on added subject matter. So that was a bit of a workaround that we found in this situation. Removal, replacement of a feature related to an intended purpose. This one is a bit tricky to get your head around. At the EPO, a clause with a for is usually non-limiting. So this means that if you have a handle for a door, you can still have prior art cited against you where that exact same handle is used on a window or something else, or a car. It doesn't really matter. And what happened in this particular case was, presumably during prosecution, they said, well, for is not limiting, so I'm going to take out the for clause. And in this case, it was a packaging material for paper containers. But during opposition, the Board of Appeal held that for paper containers did impart some sort of limitation because the packaging material had to be suitable for that purpose. So even something that on its face may not appear to have much value is still something worth including, like keeping in your claim. And this, I think, goes to something that we're going to touch on right at the end of our presentation about tidying up the claims. If you think, unless there's a specific reason for you to tidy up the claim, and you think something doesn't really need to be there, don't don't remove it unless you really, really have to, would be my tip. So we talked there a little bit about intermediate generalization by deleting features from claims. You can add additional features at the EPO, provided that your new combination is consistent with the description, it's reasonably plausible, and obvious in view of the application. I don't really like these terms. These come from the guidelines, but in general, you have to have some sort of, and I'm going to come on to this, it's better if you have some sort of pointer to your combination. When you're combining dependent claims or adding new dependent claims, your claim dependencies are going to be looked at very, very strictly. Now, there's some case law which says that the skilled person doesn't put that much emphasis on claim dependencies because the skilled person is not a lawyer. They don't have that mindset of dependencies. However, the EPO still, particularly examiners, overwhelmingly seem to rely on claim dependencies. So if you were found to have an intermediate generalization and the examiner says, no, I'm not going to allow your amendment, what can you do? Well, you don't have to try and argue that it's not an intermediate generalization. So you have to try and argue that whatever feature you put in your claim is not inextricably linked to the other features that it's disclosed alongside. So let's say you have an engine, and the engine is only disclosed in combination with being inside a saloon car. But really, the engine is the invention. What type of vehicle it is not really the invention. So in that sort of example, you may be able to argue that the type of car is completely separate from the type of engine. I would just add the caveat that such arguments are probably not going to meet the EPO's gold standard test because the EPO tends to take the view that you could have claimed whatever you wanted. You drafted the application, and I use you very widely to mean the applicant or whoever drafted it for the applicant. And you could have used whatever language you wanted, but you didn't. And that's making it harder to argue against intermediate generalization. Nevertheless, there is something worth trying there. So we have a poll question, and this comes from the case law. So an amended claim relates to the heddle for the harness of a loom. The heddle is like a frame for weaving cloth, basically. So the claim was limited by introducing features that were disclosed only in connection with a specific embodiment in which the eyelet of the heddle had a particular shape. The shape feature was not included in the amended claim. And in the general part of the description, it was mentioned that the eyelet could also have other shapes, such as an elliptic shape. Now, we have the same setup of the poll question as before. Does this add matter? So A is it adds matter in both jurisdictions. B, it adds matter at the EPO, but not the USPTO. C, no added matter at the EPO or the USPTO. And D, not at the EPO, but it does add matter at the USPTO. So I'm just going to head to the poll slide to give you the opportunity to add your thoughts. So a bit slower, this one. I think people are having to think a little bit harder about this. I had to Google what a heddle for a loom was, so I'm not going to hold anyone accountable for getting this wrong. So let's just have a look at the poll results. I think there's definitely a lack of confidence in the room on this one. So I think I think most people's default here is that there's added matter at the EPO, because there's always added matter at the EPO, and there's not at the USPTO. But this is actually an example where there was no added matter at the EPO. It comes from the EPO case law, and we don't think, although this analogous case didn't go to the US courts, but we don't think there'd be added matter at the USPTO either. So this is a case where there was an intermediate generalization, and the Board of Appeal said, no, it isn't. It's fine. So it is possible to extract features without falling foul of added matter, but the circumstances need to be quite specific. So as a chemist, I get the joy of dealing with selections from two lists at the EPO, and I probably deal with this pretty much every single day of my working life. For those of you, the two lists principle is pretty alien for anyone outside of Europe. And the idea is that you can add matter by making arbitrary selections from independent lists. The case law developed in the field of pharmaceuticals, and how it grew up was that people were filing applications where you had a really broad compound definition, and then you had a really broad list of diseases, and then you go away and do your data and work out which compounds you want for which diseases. And the EPOs, that's future claiming. And the EPO didn't like that. And the way that they've shut that down is by saying, well, you can't pick a disease from your original disclosure at random. And you can't pick a compound from your original disclosure at random, because those are two separate lists, and combine them. That adds matter. So I have an example which I don't want to scare anybody. I'm afraid there are some hexagons on here, but I've tried to keep this as straightforward as possible. Essentially, this is exactly the scenario that I was talking about. So the application, we have a claim where we have a fairly broad compound definition. Doesn't really matter what it is, but you have a fairly broad compound definition for use in treating cancer. And obviously cancer is quite a broad subset of diseases. The examiner finds some prior art which discloses, and the non-chemists, you'll just have to trust me, a compound falling within the scope of your claim that is disclosed for treating lung cancer. So this is novelty destroying. But, aha, you say, well, we define cancer as all of these things. We've got bladder cancer, breast cancer, colon cancer, rectal cancer. So we'll just pick one of those. As long as we're not lung cancer, we're novel. So your claim is amended. You still have your broad compound definition, but this time you are limited to breast cancer. This is great, but the examiner finds a new piece of prior art with a compound, again, falling within the scope of your general formula. And this time it's disclosed for use in treating breast cancer. Now, you don't have a narrower fallback for breast cancer. So you're going to have to find a compound definition to fall back to. But in the application as originally filed, there are three different options. There's a list of three options for the X substituent. And you decide that since in the prior art, what they're calling Y, but is X in your compound, can be S or O, that's sulfur or oxygen, you decide you're going to limit to NH only. So here are the two amendments. You've restricted to breast cancer, and you've restricted the X definition to NH. Does this add matter? Well, I've set this up in quite a tricky way, because the way I've presented it is as a list of cancers and a list of X definitions. And so on the face of it, those look like two lists and independent selections from two lists. Now, you may be able to argue that it does not add matter if you could say that there was some pointer and to this combination, but certainly on its face, this looks like it adds matter. And I think this is where it's a bit confusing for US attorneys. So, Sarah.
So with respect to the US, I would say that it does not add new matter. But I will say that when I worked in the US, I never came across this in my practice, an objection due to a selection of two lists that this may be added subject matter. This is something that came into my awareness once I moved into Europe and I started training to become a European patent attorney. And as Vicky said, this is an issue that's heavily associated with pharmaceuticals, but it does come across in electrical practice every now and then, definitely not as often. But when I was in the US, it's not something that I ever had to deal with. And there's no section in the MPP which deals with this point.
Yeah, and essentially, so I see instructions coming through from US counsel or just my colleagues within Finnegan in the US, and the number of times I have to turn around to them and say, no, you've selected from two lists. It's not restricted to pharmaceuticals. This example is a coating composition. You have three separate components. Just in the interest of time, I'm not going to run through this one in a lot of detail, but you will get the slides later to have a look at this in your leisure. Similar situation, you have some prior art, you decide that you're going to make one amendment, and that's arguably at first selection. You have a second piece of prior art, you then decide to make, again, arguably a second selection. And again, you're going to be in a situation where you're not adding new matter in the US, but you might in Europe. So how would you rescue yourself from a two lists objection? Well, look, the most effective way to rebut the objection is to show that the new combination of features is foreshadowed in the application. So going back to the breast cancer and specific compound example, if you could show that maybe all of the data is for breast cancer and is those sorts of compounds, you could argue that that was quite a strong pointer. Alternatively, it might be a preferred embodiment. If breast cancer was repeatedly called out as preferred, that might do it, or it might be clear through the claim dependencies. There's also an argument that you may be able to argue that the list is not a list. And because according to the case law, the lists must be of some length, which is really vague and unhelpful. But you could say that you have, for example, alternatives. You have A or B, and that's not a list. That's just two alternatives. So that there is some things you can do there. And it's worth noting that selecting from two lists is not allowable, but a single selection is allowable. This is another example moving on to the clarity added matter trap at the EPO. And this is another example that haunts me from my days as a trainee. I was dealing with, in prosecution, with a case where the claim as filed related to a composite comprising wood fibers and small glass bubbles. Now, the relative term small was considered to be unclear by the EPO, and I think that's, perfectly justified. But if the term was deleted to overcome that lack of clarity objection, the scope of the claim has been broadened from only small glass bubbles to any sized glass bubbles, adding matter. And in the case that was particularly problematic for me, they'd just forgotten when they were drafting the application to define what they meant by small. So we couldn't define the term, we couldn't delete it, and we couldn't get it allowed because it was unclear. So we were completely stuck. Again, this is something that tends to come up more in the chemistry and life sciences space, which is the addition of disclaimers. So a disclaimer is a negative claim limitation. There are 3 different types of disclaimers that can be added at the EPO. The first type, disclosed disclaimers, these occur when an application already disclaims the feature. So you may have claimed a metal climbing frame, but the application says that the metal is preferably not tin. So in that scenario, you can put that disclaimer into your claim 1. Undisclosed disclaimers are more interesting because they're not disclosed in the application at all, but they can be added in very limited circumstances. So restoring novelty over novelty-only prior art, restoring novelty over an accidental anticipation, and to remove subject matter excluded from patentability. And because we're going to have a poll question on this later, accidental anticipations arise when the subject matter of the prior art is very far removed from the invention at hand. And the classic example from the guidelines is diapers and tanks. You may have some crossover in the materials, as we'll show you in the poll question later, but I don't think anyone is going to argue that those are closely related technical fields. The third sort of disclaimer is where your application discloses something positively, and yet you want to disclaim it when amending the claims. So for this type of disclaimer, the added matter test is the gold standard test. So whether the subject matter remaining in the claim after you've added the disclaimer is directly and unambiguously disclosed to the skilled person. I'll hand over to Sarah now to compare the comprising and consisting of language.
Okay, so here's just a comparison of some of the traditional, the transitional phases that we use in claim language. So here is an example of how this is described in the EPO. So comprising is an open-ended term. It includes everything that is provided within the claim and also includes features which are not explicitly provided in the claim, other features. Consisting of is a closed-ended term. It just includes the features which are explicitly recited. And this is generally used with Marcouche group claims in order to claim a specific group of alternatives. And this is just provided exactly from the guidelines. And also comprising does not provide implicit basis for consisting of or consisting essentially of. And we have the same exact treatment in the USPTO. Comprising is evaluated as an open-ended term and consisting of as a closed-ended term. And during drafting, comprising is generally what's used. And here we have a comparison of how the correction of errors is treated in the different jurisdictions. How easy is it to amend your specification, for example? So in Europe, this is dictated by Rule 139 EPC, and it's quite a high bar. So basically any linguistic errors, any errors or mistakes in the document may be corrected, but the correction must be obvious in the sense that it is immediately evident that nothing else would have been intended other than what is offered as a correction. And so there's a 2-step test in determining this. Number 1, the first step is whether or not the error is obvious to the skilled person. And number 2, is the correction obvious to the skilled person? So that is the requirement for the EPO. And in the US, in general, I would say that it's easier to correct the specification and also things like a sequence listing. And so these are excerpts from the MPEP and rules which allow for substitution of portions of the specification and also sequence listing. And not to say that it's extremely easy to completely substitute a new portion of the specification or a sequence listing, but the fact that these portions of the MPEP are set in place and that there are rules dictating this already removes you several steps from what's offered at the EPO. So in order to make these substitutions and amendments, you have to particularly point out what corrections are being made. And you also have to make a statement that anything that you're including does not have new matter. So there is still the standard that you cannot add new matter. And the statement is important because we do have inequitable conduct in the states. So if you are found to purposely mislead the EPO, then that could invalidate your patent. And so here I'll turn over to Vicky for a life science example.
Yeah, so this is an example that concerning a sequence listing. So you sometimes find that there's an error in a sequence listing, and these can be particularly difficult to correct. And the reason I've included this example is this is something where, again, you probably can't correct, on the basis of the facts that I put on the screen, you probably can't correct this sequence listing at either the USPTO or the EPO. The big difference is that the USPTO will allow you to use the priority document as basis for the correction. So if the error was introduced, say, on your PCT filing, you may be able to argue in the US that, look, it was correct in the priority document and it was just a mistake when it was converted. At the EPO, the priority document is not part of the application as filed, so you don't have that to fall back on. So the correction of errors can really be quite difficult in both sides of the pond. A slightly more optimistic example, where we at least meet part of the test, is a claim relates to a method of smelting aluminium at a temperature of above 80 degrees Celsius. Now, aluminium doesn't melt at 80 degrees Celsius, so the first criterion, i.e., is the error immediately evident to the skilled person? That's satisfied. It's even a non-scientist would know that aluminium is not going to melt at 80 degrees Celsius. But what should the correction be? Because 800 degrees could be correct, but 850 could be correct too. So it's not immediately evident what the correction should be. And this is why you have to turn to the description and hopefully have some sort of disclosure in there to help you make that correction. So we're going to look at some of the post-grant considerations now. Sarah.
So I'll talk about different grounds for invalidation within the patent office. So this is not litigation outside the patent office. This is just for proceedings within the EPO and the USPTO. So within the EPO, we have oppositions. And when it relates to the patentable subject matter, there's generally 3 grounds that you can oppose a patent for. That's going to be novelty, inventive step, and patentable subject matter. You can also oppose a patent for inadequate disclosure under Article 83, and as well for added subject matter. So in the USPTO, there's 2 possibilities for challenging a patent. So first we have post-grant review. The window for this is relatively short. It's 9 months after the issuance of the patent. And here there is a greater greater selection of grounds that you can challenge a patent. So you have patentable subject matter, novelty, obviousness, and also the requirements of 35 USC section 112, which includes written description. And again, written description is more often than not closely aligned with added subject matter. Once you're outside the 9-month window, then you have to rely on inter partes review, IPRs. And here you're more limited. So with IPRs, you're limited to grounds related to novelty and obviousness, and only on the basis of prior art comprising or consisting of patents and printed publications. So now I will leave it to Vicky to talk more about post-grant proceedings in the EPO.
Sure. So the assessment of added matter has become stricter over time. The gold standard that we've been talking about quite a lot was introduced by a legal decision that published in, I think, 2015. But we often find that there's kind of a hierarchy where the examiners are sort of at the bottom in terms of how strict they are. The opposition divisions tend to be a little bit more strict, and then the boards of appeal tend to be even stricter. And there's no presumption of validity at the EPO. So even if you got something granted, it doesn't mean it's good for added matter. And added matter it's raised in pretty much every opposition. If any amendment is made to almost any part of the application, your opponent is going to jump on that for added matter. And they're particularly going to jump on any arguments that you had to file. So if you tried to correct an error and you argued that the two-step test was met, then the opponent is just going to say, well, you didn't meet that test, and therefore you add matter. And that is exactly an argument that I've made as an opponent. So yes, people do it. There's a particular issue that comes up during EPO proceedings called the added matter trap. Everything we've talked about so far has concerned Article 1232 EPC, which says that you can't extend the scope of your patent application to include subject matter that was not in the application as originally filed. But Article 1233 says that you cannot broaden the scope of patent. And you can find yourself in a situation where you put in a limitation during prosecution that you can't keep because it violates Article 1232, but you can't get rid of it because it broadens your claim. As a very simple example, your claim is originally filed as a bicycle frame made of metal tubes. During prosecution, you amend that to aluminium tubes. But the opponent successfully argues that aluminium tubes, there's no basis. Maybe it's an intermediate generalization, who knows? But the patentee can't fix this by reverting to metal tubes because that's broader than the claim is granted. And as we talked very briefly about disclaimers, and the EPO allows undisclosed disclaimers in very limited circumstances. But the disclaimers have to be written in such a way that they do not remove more subject matter than necessary. Problems can arise, and you can find yourself in the added matter trap if a patent grants for the disclaimer, but it's later found that it didn't meet one of the limited circumstances where a disclaimer is allowed, or if the disclaimer wasn't drafted correctly and it's too broad. So that leads me on to my next poll question, which is concerning this idea of accidental anticipation. Do you remember the diapers and tanks pictures we had earlier as totally unrelated technical fields? So when Claim 1 is filed, was a diaper with polymers A through G, various other features, and in prosecution, it was found that polymer A was known for use on the underside of tanks and armored vehicles for absorbing impact. And you successfully argued in prosecution that this is an accidental anticipation, and you therefore added a disclaimer to say that the polymer is not polymer A. At opposition, new prior art is cited, disclosing polymer A for use in clothing. So is the disclaimer still valid? Yes or no? So I'm going to hit to the next slide to allow you to put in your answers. Ooh, again, I think this one is a bit more complicated. Answers are coming in a bit more slowly here. Okay, so we've had a few responses. I'm just going to flip forward to the results to have a look at what people think. Oh, interesting. Now, The point here, I think, is that the disclaimer was added on the basis of two totally unrelated prior art documents, diapers and tanks. There are no similarities between diapers and tanks. There is no overlap in who the skilled person is for diaper technology and tanks. But once you get into clothing, then you are less likely to have this accidental anticipation situation, because a diaper is essentially disposable clothing for infants. But, so I would say in that scenario, your disclaimer is no longer valid in light of the new prior art. Obviously, there's lots. It's very much a debate situation, so I can't give you a definitive answer without going into all cases in detail. But I would say on its face, the addition of the new prior art means that your disclaimer is invalid and needs to be removed. And therefore, your claim adds matter. So escaping from the added matter trap is difficult, but not impossible. When we looked at the bicycle made with aluminium tubes, we said aluminium wasn't an allowable amendment and it added matter. And that may be true, but do you have basis for, say, aluminium tubes of a specific thickness, specific length, something like that? Is there an extra limitation you can add in that fixes your added matter problem? And if your claims grant with a disclaimer, the best practice is to file auxiliary requests or fallback claim sets that are unambiguously novel, so that don't require the disclaimer in the first place. And how can you avoid getting into this situation in the first place? Well, it's easy. Don't add matter. But that's going to happen. So what I would recommend is for contentious portfolios, or if you think an opposition looks likely, do a stress test of your claims prior to grant. So once the application is in order for allowance, the EPO issues a copy of the text proposed for grant. At that stage, it is worth reviewing the claims for potential added matter issues, and you can fix things more easily before grant. There isn't a huge amount of flexibility for amendments at the EPO, but you at least won't be caught with this issue of not broadening the scope of the claims. So that's something that I very strongly recommend. So we're moving into our final section now, which is our practical hints and tips. So I'm going to hand over to Sarah.
Great. So we'll just go over some tips to preemptively overcome some of these problems that we may be having by the differences in jurisdictions. So first, let's talk about the combination of features. And we previously discussed that this is much more difficult to do in Europe. And it's not guaranteed it will work in the US, but it's easier. It's not as a rigid of an evaluation. So generally, US applications are drafted with boilerplate point language and heavy usage of the word may. And examiners do not give a lot of weight to this, and they generally don't like to see heavy usage of the word may, and they often require that this is removed from the application. And the argument of that is that you haven't really defined the invention if everything is optional. So one tip to overcome this is to ensure that when you're drafting the specification, that the independent claim is described with more definite language. And to keep in mind that during prosecution, you are amending a dependent claim and putting it up to the independent claim to really try to focus in the written description and try to remove the may language with respect to the dependent claim that has gone up to the independent claim. So just make an effort to try to carry that through during prosecution. So when you receive a notice of allowance from the examiner, you don't let the examiner make amendments and deleting the word may, or the examiner requesting for this to happen towards the end of prosecution. It might be useful to carry this throughout. And very important to make sure that the independent claim is described with more definite language. And so moving on.
Yeah, so as I sort of explained in relation to the two lists principle, added matter objections often arise when new combination of features are presented. So you need to ensure that all combinations are explicitly disclosed, or that there are pointers to all combinations. And that might mean writing out all the combinations you can think of. EPO case law suggests that you can add the term preferably. And as a European attorney, that's something I really like. But so we're going to hear from Sarah, that's not always the best thing to do.
So here we have a list of patent profanities. These are words that in the US, as someone drafting an application, you try to avoid very much. So all these words are associated with different cases. We're not going to go into any of the cases right now just to save time, but they're there for your reference if there's a particular word that you would like to investigate more. But the main thought behind this is to make sure that all the embodiments and the features are described on the same level. There's not a particular embodiment or feature that's highlighted as being preferred or better. And the reason for this is to ensure that during claim construction, there isn't anything in the application that could provide you with a narrower claim. You don't want someone to argue that there's been a particular feature or embodiment that's been highlighted in the application and therefore should be limiting with respect to claim construction. So these are all limiting words or words that highlight a particular feature or embodiment. You have preferred, very important, critical, essential, necessary. And we've also included the phrase, the invention is. And when I came from the US and then I started my training in Europe, this is something that I found that a lot of European patent attorneys had a problem with, to delete the word invention. And so even when I'm drafting my application and you have the subheadings, the summary of the invention, I will delete the word invention and just have summary. And you'll have written description of the invention, and I will just, or detailed description of the invention, and I will just have detailed description. And the argument for that is that, you can argue your application doesn't really disclose the invention. The invention is a huge umbrella, is under a huge umbrella, which includes your application as well as multiple equivalents of what you've described. So to have a very definite statement in your application saying that the invention is, that could be damaging, especially with respect to US. And when you're training in Europe and you're preparing for Paper D and the EQEs, it's kind of what you're trained to do. This is the problem solution approach, or when you have the problem statement in the application, it's what you have to do on the examination. But I would argue in practice maybe it might be a good idea to relax that in order to be in harmony with the two jurisdictions. And so here we have examples from the US where you really have to define the claim and consistently use terms. And here are some examples where failure to do that have caused a problem in an application or granted patent. So in the first one, union specific, there were two terms which the court said were not properly defined. So we have comparing. And in the claim, the courts deemed that there was a complex correlation going on, but the word comparing in the application wasn't described adequately enough. So this was objected to with respect to written description. And here there was a rescaling algorithm used. And here they found that union specific did fail to include the details of this algorithm. So this was objected to for enablement. We have aqua aerobic, and here there was two phrases used. So there was a prevent the flow of air, and there was also a phrase directed towards preventing a passage of air. And now most people would probably read those phrases and appreciate that they're very similar, and perhaps many people would say that they mean the same thing. And here the patentee even had an expert attesting to the fact that these are the same thing and they should be evaluated the same. But the court disagreed, and the claims were construed differently based on these the use of these two terms. And also in Ortho McNeil, we have in the specification, there were multiple ranges that were described, and some of the ranges were described with the word about, and some of the ranges were described without the word about. And the court said that, well, in some of the ranges, since you've left that word out, perhaps it was on purpose. And they did construe the ranges differently, depending on whether that word about was associated with it or not. And when I think of this case, I imagine that a European examiner may do the same, to be honest. If you describe some embodiments with a particular word and other embodiments without a particular word, that could be a problem in Europe as well. But again, this would have to be evaluated on a case-by-case basis. And moving on. So here's just some tips for the combinations as well. We'll talk about claim dependencies. So in Europe, basically all applications, I would say 9 out of 10 applications have multiple claim dependencies. It's standard practice for drafting a European patent application. And in the US, it's not typically done. And the reason it's not done is because it's extremely expensive. So just for having the right to use multiple claim dependencies, you have to pay a fee. And that fee is just under $900. And in the US, each and every possible claim combination is going to be counted as an individual claim. And you have to factor that in when it comes to paying your claim fees. So in the US, every claim over 20 claims is $100. So it's a $100 claim fee. So you can imagine if you have 30 claims and all of those 30 claims are dependent on each other, it's extremely expensive. So for that reason, US applications are not filed with multiple dependent claims. But one way to overcome this and to provide the support for the different combinations that you have with multiple dependent claims is providing a numbered list of embodiments. So basically what this is a cut and paste of the claims that you put at the end of your specification. And instead of the word claim, you just write embodiment. So you can have summary, a list of example embodiments, and you can have an embodiment or, a device A, 2, the device according to embodiment 1, and then so on. So very similar to the claims, and then this will give you the literal support. And I would say that it's very important to do this also for priority applications. So often in the US, when you file a provisional application, they're often sometimes quick and dirty. A provisional application doesn't require claims and it's not examined. So a provisional application can be a thesis or a presentation. And what I would recommend is that all of these provisional applications do comprise a claim set, and that claim set have multiple claim dependencies. Because in opposition, one of the first things that a European examiner or a European attorney will do is will look into that priority document and see if priority is valid and do you have support for the different combinations and for your multiple claim dependencies. And so another tip, don't be subtle, make sure that all the combinations that you can think of are clearly supported in the application, and if possible, have specific pointers to different combinations while keeping the US standard in mind and describing everything on an equal level.
Yeah, thanks, Sarah. I mean, one thing I do, and I've just done a draft recently, we included a hideous 300 claim set for meeting the US requirements. But at the end of the specification, we included a shorter claim set, which has multiple claim dependencies, and that is our European claim set. So when we enter the national phases, we can just ditch those PCT claims, and we have the European claims with their multiple claim dependencies. They're in the PCT, they're in the priority application. So we've got basis for all our combinations going back to the priority document. So as we've discussed, comprising does not necessarily provide basis for consisting of or consisting essentially of. So if you think you may need the narrower language, put it in your specification. Removing features from claims can be quite difficult. So in general, I would say draft with broader claims, but ensure there's basis to add in your features later. The compromise position might be there that you draft with broader claims to begin with, and then have some picture claims that give you your combinations. That might be an alternative. Adding disclaimers during prosecution is generally something to be avoided. So I would always recommend going for positive limitations instead. And when you're drafting, it's worth keeping in mind the basis has to derive at the EPO from the application as originally filed. And that the abstract is not part of the application as originally filed. The title is not part of the application as originally filed. The priority document is not part of the application as originally filed. Information that's incorporated by reference is generally not part of the application as originally filed. So you really need to make sure that whatever you might want to claim later is in the claims or the description. And it's worth pointing out that at the EPO, you can't rely on the examples and figures as basis for amendments, although that's quite different in the US, Sarah.
So in the US, you can absolutely rely on the examples for amendments. And with respect to figures, I would say it really depends on the figure and what information you're trying to extract from the figure. So if your figure is not drawn to scale, then it would be difficult to try to get an exact dimension from that figure. So that would be evaluated on a case-by-case basis. But generally, it would be easier to base an amendment off of a figure. But again, it depends.
So as in my glass bubbles example, ensure that any potentially unclear terms and any relative terms are defined in the application. Don't assume that you'll be able to rely on the common general knowledge. At the EPO, evidence of the common general knowledge is not so easy to find. It has to be a textbook or a manual, an industry standard, essentially something the skilled person would have lying around in the lab that they can show to the EPO. And it's extremely common that the document just doesn't say what you want it to say. So I would always define everything as much as possible. Sarah. Oh, I think you might be muted.
Thanks. So here are just a few tips and guidelines for when a US attorney gives instructions to European counsel and vice versa, when a European attorney is giving instructions to a US practitioner. So I would consider, as a US patent attorney, maybe asking an EP attorney to review a draft application prior to filing, just to make sure that you have adequate support for all of your different combinations and all of your fallback positions are properly supported. And as a US practitioner, one thing that's difficult for European attorneys is when you're in prosecution and you get suggested amendments from US practitioners. I would just advise that US practitioners really try to indicate where literal support is and just keep in mind that it is a stricter standard. And so it would be helpful if you can just point to the different areas of the specification of where the support is found. And for European practitioners, I would ask to consider or recommend to consider to use a broader claim interpretation. Remember that the evaluation of added subject matter is not as strict in the US, and to perhaps consider that if you're trying to claim an embodiment and you're not claiming all of the features that are disclosed in that embodiment in the specification, it may be difficult in Europe, but may be more allowable in the US. So just to keep it in mind. And also, again, as Vicky had stated previously, because there's such a need for literal support in Europe, when you amend the claims and you combine different dependent claims in an independent claim, there might be a tendency to kind of tidy up the claims and make sure it reads well and take out limitations that you think are not necessary. But as Vicky will explain in the next example, that could be detrimental.
Yeah, it's something that I think particularly we see when US attorneys are instructing European attorneys in London, because the US attorneys speak English as their first language usually, the European attorneys speak English as their first language. So there's a huge temptation to sort out the grammar and make sure that the claim is neat. But you could be removing your literal basis. And so that's really something to look out for. I just have a kind of little anecdote that I want to include on literal basis, because an old boss of mine, she used to get her claims checked for added matter not by a colleague, not by an associate, but by her 10-year-old daughter, because her 10-year-old daughter was very good at spot the difference. The children's game where you have two pictures and you have to see if you can find the differences between the two pictures. And essentially that is what EPO added matter analysis is really like. So it's kind of a bit of food for thought. You know, if a 10-year-old couldn't spot your amendment, you could be adding matter.
So just a few takeaway points and key things to remember. So again, build in basis for the combinations at the drafting stage. This is especially important for any applications that may eventually end up in Europe. So consider, if you're in the US, consider adding a list of numbered embodiments as we described above. Make sure that there's adequate support for all the different combinations. And especially important to make sure that these numbered embodiments are in priority applications, in particular in mind US provisional applications. And assume that examples and figures are merely illustrative. So as we described before, in Europe, it will be more difficult to use an example and a figure as a basis for amendment. So in the example, the examiner will more often than not require you to use all of the features provided in the example. So make sure that you clearly state that the features that are optional are highlighted, and you clearly spell out or provide pointers for specific combinations.
Yeah, and our final key takeaway is to just take care with amendments during prosecution. Added matter is so often fatal at opposition, and it's really easy to put on your "I want to get this granted" hat, and not your "is this defensible" hat. And it's particularly difficult if the examiner has maybe implied that something is okay. Don't trust the examiners. The opposition division won't. The Board of Appeal won't. So just take care with what you're doing at prosecution, and really think, particularly if you're on a highly contentious portfolio. And with that, I'm going to hand over to Darren, as we've got some questions coming in.
Thanks, Vicky. Thanks, Sarah. Before we begin the question and answer portion of the event, though, please take a moment to complete our brief evaluation survey. As we strive to provide programs of value and continually improve, we would appreciate your input, which will guide us in planning future programs. So now a couple of questions. The first one I'll take, because I was actually, while the seminar was going on, I was trying my best to answer a couple of hypotheticals, and I'm not sure that I really communicated that well, but I think the questions really were directed to the US. When you have, say, a detailed description section that talks about element A maybe combined with element B, and maybe combined with element C. And then the detailed description doesn't mention anything about D or E, but in the claims, you have element A, and maybe a dependent claim says it's combined with D, and another one says A is combined with E. And the question was, is that okay? I think the question was going at, is it okay to have claims that are directed to any of those combinations, A plus B, A plus E, all the things, and you don't have the detailed description specifically mentioning D and E? And the answer, I think, that Sarah was describing is yes, that's okay in the US, because, and I think the key thing here is that the claims as originally filed in the US are considered to be part of the specification. So whatever you put in the specification is just like it was put in the detailed description. So hopefully that's helpful. Let's see, one question here. Does the issue of intermediate generalization extend back to priority documents? So suppose you add claims when entering the EP from the US and add multiple dependent claims with perhaps different alternatives.
Yes. This is the simple answer. You will probably lose your priority. So if your PCT application claims new combinations of features that were not disclosed in your priority application, then you probably lost priority. So it's really important that these combinations are in the priority document as originally filed.
There was a question about the word substantially. Maybe Vicky and Sarah can comment on how substantially it is viewed both in the EP and in the US.
Oh, well, EP is easy because they just ignore it. It would have to be deleted. Unless you had some sort of definition that's provided for the term. But in my experience, it's always put in by US attorneys drafting applications, and then European attorneys just take it out again.
I would say it depends on the field, and it depends what the skilled person appreciates. Is it common? And I think you need more information with respect to that question, but it depends. That's my answer.
Cop out.
What about, I think there's a hypothetical about when you have a particular compound that may be used to treat certain cancers. The question is, what if you had a compound of claim 1 and then there was a broad list of cancers described in the specification that can be used to be treated with claim 1? Can you say, for example, claim the compound and then have multiple dependent claims that talk about using that compound for treating each one of the cancers?
Yes, please. That's what the EPO would like to see. The way to get around the excess claims fees with that situation would be to have a multiply dependent numbered embodiment section where you have all these combinations called out. But you know, if you've got 15 cancers, you've automatically got 15 claims. You don't want to run up massive excess claims fees. So when you're drafting, I would put those all the combinations you can think of into a numbered embodiment section in your description.
Speaking of embodiments, recent question: would you comment on any different treatment for the terms example versus the term embodiment?
So in the US, I would say that it depends on how it's used, but in the US, I would say that embodiment and example is treated more similarly. What do you think, Darren, as a former examiner? How would you?
Yeah, absolutely. I mean, I think like you were talking about earlier, Sarah, the word invention is the problematic word, and only really in the context and needing to be careful about saying the invention must include this, or the invention has these features, and that's why we try to avoid the word invention, because it can unintentionally lead to those unintended limitations. On the other hand, the words example or embodiment are safe words and kind of treated synonymously, but because both of those have the advantage of conveying that this isn't the full scope of the invention that I'm talking about. This is merely one example or embodiment, one part of, one thing, not everything.
I think at the EPO, you would normally see example limited to specific examples that have been carried out, particularly in the field of chemistry. Those might be your synthetic examples or your data. The embodiments, if they're very specific, then there's no real difference between an example and an embodiment. In general, the embodiments tend to be used just to call out features. The problem is that the features are all called out having the same hierarchy, and that then leads to problems making combinations.
So I think we have time for one last quick question. There were multiple other questions, and we'll try to get to those after the webinar. The question was similar to one that we had before the webinar began in the solicitation. It's can the more freedom in amending claims in the U.S. during prosecution be a problem later on in court in the U.S.? And I think this is interesting because it really is a bit different than exactly what Vicky said were the problems in oppositions, that amendments can be fatal. And in the U.S., it's most likely not to be fatal. It can be, but most likely not. And that's because there's a presumption of validity that the courts will apply. The courts will presume that the USPTO did their job correctly, And only with clear and convincing evidence, if there was an error, would they go back on that determination. And that concludes our webinar for today. Thank you all so much for attending. Vicki, Sarah, great job, and thanks for the presentation.